Good afternoon. My name is Renee Spence, and I am NACDL's Public Defense Reform and Training Council, a part of the public defense team at NACDL. Thank you for joining us for our HIV Criminalization webinar. This webinar is a product of a collaboration between NACDL and the Center for HIV Law and Policy. Kate Bolton and Tosh Anderson from CHLP have been instrumental in making this webinar a reality. Also, this webinar is supported by grant number 2013-MU-BX-K014, awarded by the Bureau of Justice Assistance. The Bureau of Justice Assistance is a component of the Office of Justice Programs, which also includes the Bureau of Justice Statistics and the National Institute of Justice, the Office of Juvenile Justice and Delinquency Prevention, and the Office for Victims of Crimes and the Office of Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking. Points of view or opinions expressed are those of the presenters and do not necessarily represent the official position or policies of the U.S. Department of Justice. 34 U.S. states and territories have criminal statutes that permit prosecution for allegations for non-disclosure, exposure, and although not required, transmission of HIV. Oftentimes, these laws are felonies, and the collateral consequences that accompany these convictions rival those or sometimes exceed those associated with attempted murder convictions. And so while we may not encounter HIV-related crimes and charges in our normal caseloads, and as often as we encounter grand theft or possession of cocaine charges, the consequences of failing to provide effective assistance of counsel are severe. Defending these cases requires an interdisciplinary approach, a legal approach, a medical approach, health, ethical, and sometimes a psychological approach. What we hope to do in this webinar is to equip you with the tools to approach these cases in a way that will make not only the client feel comfortable, but for you to feel comfortable representing our clients. We want to provide you with the medical primer for HIV education. We will speak about health disclosure and the ethical issues that accompany such disclosures, as well as address or get you to start to think about internal biases that the judges may have, law enforcement officers, prosecutors, and even ourselves. Joining us today is Dr. Wohl, who is an MD and a professor of medicine in the Division of Infectious Diseases at the University of North Carolina, UNC at Chapel Hill. He co-directs HIV services for North Carolina State Prison System, as well as he is the site leader of the UNC AIDS Clinical Trials Unit at Chapel Hill and the director of the North Carolina AIDS Education and Training Center. Accompanying him to his left is Stephen R. Scarborough, who is a criminal defense attorney in Atlanta, whose practice focuses on appellate and post-conviction matters in state and federal court. He is interested in the intersection of the criminal law and public health and has represented several persons who have been accused of HIV-related offenses or are subject to enhanced sentences on account of their status. He is part of a community effort to replace Georgia's outdated HIV-specific reckless conduct statute, which imposes felony liability in a broad range of cases where transmission of HIV is nearly or totally impossible. The webinar will be presented in two parts. We will start with a medical primer, and the follow-up part will discuss the legal strategies for litigation. At the end, we will take questions, and you can email your questions to idominguez@nacdl.org. It's idominguez@nacdl.org. And we'll present the questions to our presenters today, and hopefully we'll have a robust discussion.
Great. Thank you. Thanks, Renee. Thanks for Steve. This is really a wonderful opportunity, and I'm glad that we're discussing this today and that the association is supporting this, and that many of you have chosen to take time out of your day to listen to us and also to view this online after it. So what I'm charged with doing is presenting the primer that we were just discussing, just some basic facts so we are starting on the same page so that when we start talking about some of the legal issues, we all have a similar understanding of some of the basics of HIV and HIV transmission. So I think it's really important just to try to make this sort of as distilled down to the facts as possible. And really, there's only 3 ways that people on planet Earth can get HIV. One is through blood and blood products. So we see this when we share needles that are contaminated with blood from somebody who's HIV infected, and someone who's not HIV infected uses those needles or uses the equipment. And then we have sexual, which is the overwhelming leading mode of transmission on the planet, where 2 individuals will have sex, one person is positive, one person is negative, and that includes penile-vaginal sex, anal sex, and possibly oral sex, but we'll talk more about that in a second. And then there's something we call vertical transmission, which is mother-to-child transmission, where the mother is infected and transmit the virus to her child, either during delivery most commonly or post-delivery. So in order for any of those modes of transmission to be effective and for there to be the jump from this virus from one individual to another, there's a few different things that have to be considered. One is infectiousness and the other is susceptibility. So infectiousness has to do with how catchy this pathogen is. And there are certain things that we know are very catchy. You touch a doorknob, like with a cold virus, and then you put that to your face, you're pretty much guaranteed to get a cold. But there's other things like E. coli, and every one of us has sponges in our sink right now, and there's going to be a couple little E. coli pathogens on that sponge. It doesn't mean we're going to get sick just because we use the sponge. So it's a lot to do with inoculum, which is just a fancy term for concentration or how much we have there. And then there's characteristics sometimes of the virus, and there's some strains of HIV across the planet that are more catchy in certain modes of transmission versus others. But by and large, it's really a function of how much virus is present. And that's going to be really key when we start talking about some of the activities, behaviors that can lead to transmission. And if there's not a sufficient amount above a certain threshold, we're not going to have infection. On the flip side, there's susceptibility. And believe it or not every single person is equally susceptible to HIV infection. There's differences among us genetically. So we may have some hereditary resistance to infection, and that may not be absolute but relative. There may be also some acquired resistance. There may be something that we learn over time that people, after multiple exposures, may acquire some immunity. And that's what we try to do when we vaccinate people. So these are both heterogeneous, and I think it's important to understand that it's not so simple, just an exposure, and then there's going to be transmission. So there can also be amplified infectiousness. So again, this has to do with inoculum, with blood viral load. We'll talk oftentimes in HIV medicine about the viral load, and that's just how many little HIV viruses are in a drop of blood. There could also be things that propagate or enhance the amount of virus that could be present in a fluid. So in the case of genital fluids, if we have inflammatory sexually transmitted diseases like gonorrhea or chlamydia or even syphilis, we see that there's more of an immune response in the fluid and in the tissues, and that could lead to more HIV in those tissues. So someone who has a certain amount of virus in their semen, give that person gonorrhea, and the amount of virus will go up considerably. Also, as I'll show you in a second, acute infection. What I mean by that is in the short period of time after someone becomes infected, they have a lot of virus, and that will settle down and become lower. But in those first couple of weeks after someone acquires HIV, they have a lot of virus in different body fluids, including blood and genital secretions. So again, this all comes down to more virus, and in the case of sexual transmission, more virus in the fluids that can lead to infection of others. As far as susceptibility, same sort of thing. There are things that can enhance susceptibility. So it doesn't take a leap of imagination to understand that if somebody has a genital ulcer and they no longer have the protective barrier that's normally there of the skin or the mucosa, the shiny surfaces of the genital area, that's a portal for entry of virus. And so genital ulcers, like from herpes, can increase susceptibility, or from syphilis. Again, inflammatory STDs work both ways. So if I have more white cells around in my genital tract because I have an STD like gonorrhea, well, white cells are sort of the taxi cabs for HIV. HIV infects white cells, and those white cells circulate within the body and infect other parts of the body. So if we have more white cells, there's more susceptibility. Interesting, we're learning that male circumcision has a role as well. And again, it may have to do with the kind of cells that are present on the penis of a circumcised man versus an uncircumcised man. Uncircumcised men generally have more inflammation that is not detectable by just viewing. But you might be able, on microscopy, of looking under a microscope, we see that there's a little bit more inflammation, a little bit more under the foreskin, and there may be cells there that are receptive to HIV that are eliminated once we do circumcision. And there's, believe it or not, clinical trials where people have been randomized to circumcision versus not, and then followed, and we see not only less transmission, but also less acquisition of HIV among circumcised men. There's similar changes that can occur in the cervix, the female cervix of the uterus, and we know that there's some immature cells that could be present that are more susceptible, so in younger girls. And then again, genetic factors. There's differences between us on all sorts of levels genetically, and our susceptibility to HIV is included. We'll go. All right. So how do we quantify that? And this is tricky, and I would say that we should be very careful about doing this, and you'll see why. So we can try to make up some numbers about the average risk, from one person giving the virus to another, but it's very hard to do given all the factors that I just talked about. And it has to do with, well, what type of sexual activity? Not only does it matter how much virus is present, let's say, in a man's semen, but it depends where that semen is delivered, because not all of these spaces are as susceptible locally for HIV to be acquired and transmitted and then spread throughout the body. So vaginal sex versus anal sex versus oral sex have vastly different susceptibilities or transmission factors that you would think about, where oral would be very, very low and anal would be very high and vaginal kind of more towards the middle. And then not only that, but thinking about positioning. And the person who's on bottom versus on top, insertive versus receptive, clearly makes a difference too. So if we're talking about two people who are having anal sex, it depends who's on the bottom and who's on the top. And the person who's on the top, as you can imagine, would have less of a risk if the bottom person was positive of acquiring HIV, where if the infection was switched and the top person was more likely, had HIV, then that person is much more likely to transmit it to the receptive partner. The amount of HIV in the fluid I keep coming back to, and that plays an important role. And then whether or not a condom is used. And sometimes condoms are used, but they're not used correctly or consistently, but they can reduce exposure. Even if not used correctly, there may be some effect of the condom in reducing transmission. And then, as I mentioned before, sexually transmitted diseases, which can enhance the efficiency of transmission and the receptivity of the person who's negative to be infected with HIV. And then we talked about circumcision. So when we try to quantify this, we can kind of come up with some basic numbers, but each individual case would be very, very hard to quantify. So in general, just thinking about heterosexual activity, HIV, 1 in 1,000 acts is a very ballpark kind of figure. And it's based on very many estimates looking at a range of people and includes confidence intervals that can range from 0, to many-fold higher. So we just have to think about, again, how we use these numbers, and we shouldn't really apply them to individual cases given the individual variabilities that may exist for any specific circumstance. Also remember that numbers that you'll find online or in some documents citing maybe a 1 in 1,000 chance of acquiring HIV is really estimated from studies that involve stable couples where there may be less STDs, lower prevalence of HIV risk factors, and again, it may not be an accurate reflection of what's going on with any individual case. So other examples that we've talked about per 1,000 contacts, if you try to kind of get more granular, maybe for uncircumcised versus circumcised men, there may be an 8-fold difference. For individuals with a genital ulcer disease, there may be a 6-fold increased risk of acquiring the infection, and maybe a 2-fold risk for talking about someone who is the infected person, the transmitter, if you will, who's in late stage versus more of a mid stage of their HIV disease. So you can see, again, this 1 in 1,000 could be modulated based upon these additional factors. And then looking at early stage, and we'll get to this in a second, there is a much higher risk of acquisition of HIV. If you have sex with someone who's early in their HIV infection and likely doesn't know that they're infected and has higher levels of virus in their body. So again, some of these estimates come from way back, and again, I would take them with a grain of salt, but instead of 1 in 1,000, we may think about receptive anal intercourse where one partner has HIV and the other person doesn't. and the person with HIV has virus circulating in their body, maybe a 1 in 70 estimate is more appropriate. Or maybe for early stage infection, 9 times the numbers that we're talking about with 1 in 1,000 versus late stage. And again, the same sort of things we've talked about before. Again, this is all in the absence of therapy and control of HIV. So as I talked about before, early versus late matters. And I think, again, I don't want to get too detailed in this, but if you look at the red line, that's the amount of virus a person has in their blood after acquiring HIV. So on the bottom you can see in weeks. So about over the first 6 to 9 weeks, you might see a real peak in the amount of virus, viremia, that a person has. This might be measured in millions of virus per drop of blood. And then the body starts to fight back. We're not completely defenseless, and our immune system revs up and tries to fight this infection. And there's some equilibrium that's reached between the virus and the immune system, and that stays pretty stable, where the viral load will stay at a set amount generally for a long time until the very later stages of the disease, where people get more symptomatic and sick, where we see this, again, this rise in the amount of virus in the blood over time. What we also see is that the immune system will start to go down, and that's the blue line. But the red line is what I think we have to really concentrate, because you can imagine that if someone is having sex with somebody during this period, their risk of acquiring HIV would be much higher, because there's just so much more virus. And again, this is often a period of time where someone doesn't know that they're infected. And then again, late stage, we might see also an increase. Oftentimes people are sick and they're not as active, but they could be. So viral load matters. Here's another schematic. And here's more modeling that shows the risk of transmission and how high it is during this acute infection versus the more asymptomatic stable portion, and then later on during more advanced cases of AIDS. When people get on therapy, we reduce their viremia. We reduce the amount of virus. So there's much less virus around. And that's really important, because not only are we doing this to benefit the individual, but there's increasing data that shows that this benefits public health. So there's a large study, federally funded study from the HIV Prevention Trials Network, where they took positive and negative couples, so people who are in this discordant relationship where one person was HIV positive and one person was HIV negative. These are in countries where the positive person was not eligible for HIV therapy due to having a good immune system. So there was some rationing of care at this point. And then the positive person was randomized to start HIV therapy versus not. And so I'll try to keep the color code, but you can see green will be immediate HIV therapy, orange will be delayed HIV therapy, and the primary outcome was looking at the negative partner and how many stayed negative. So how well did it work? Remember, we've got couples, some were positive men, some were positive women, randomized like we talked about, large numbers of couples. And what we could see is that overall there were 28 transmissions from the positive partner to the negative partner. But only one of those transmissions occurred in a couple where the positive partner was started on HIV therapy. And that transmission occurred within 8 weeks after he had started his HIV therapy, where there was not enough time to get the virus load down. So this person still had virus in their blood at the time that they transmitted. Probably if the sex act happened maybe just a few weeks later, there'd be no transmissions in this arm. That means that 27 transmissions occurred in the couples where the HIV positive person was not on therapy. There's not any more. The numbers are small because the study was stopped early because it was unethical to continue given the difference between the two. That's a 96% reduction. And again, that one case, I think, could be explained by a lack of sufficient time to have the HIV therapy work. Follow-up results I won't get into, but show continuation of this trend and the difference between delayed versus early HIV therapy even out after time. There's other studies that are a little bit more pragmatic where they follow couples, both heterosexual couples and men who have sex with men. There's a large series that occurred in Europe, and there were no transmissions among HIV positive men and women from HIV positive men and women to their HIV negative partners, regardless of all types of sexual acts and all sorts of arrangements when the HIV positive person was on effective HIV therapy. So UN AIDS, the UN agency that deals with HIV and AIDS issues has come out with a key message saying that the consensus, given the evolving data, are that those who have suppressed virus to undetectable levels, meaning the virus is so low in the blood, it's like a needle in a haystack and we can't even detect it with our tests, person's still infected, but these people will not transmit HIV sexually. And this has led to this movement, this U equals U, or undetectable equals untransmittable, movement of really advocating that clinicians, scientists, public health folks, and I would extend that as well to the legal folks, understand that people who have an undetectable level of virus in their blood, the data overwhelmingly is convincing that they do not transmit the virus to others. And the CDC has also come out endorsing this concept and had a Dear Colleague letter that tried to remind medical providers and public health individuals that U equals U is a reality and that we should get on board with it. So it's interesting, that's not the only thing that may be leading to this trend, and what we see here is that the number of new cases of HIV in the United States has been slowly going down, which is good news, because for a long time it was very stable. And one thing that's also made a difference not only is treating people who are HIV infected and rendering them really uninfectious, but also the use of pre-exposure prophylaxis, or taking medication to prevent yourself from acquiring HIV. So this is called PrEP. So many people are surprised, but there is a pill right now that people, it's approved, can take every day, 1 pill a day, that is highly effective at preventing you from acquiring HIV infection, either through sex or from injecting drug equipment. So I think that that's a major feature of sort of the landscape and what's going on, but medication isn't the only thing that really plays into this, and this is more of a public health message. But when we look at who transmits HIV, and looking at different categories of folks, there's people who are undiagnosed, and these are people who just don't know that they're infected. And as you'd imagine, there's quite a substantial number of people who are infected from such individuals, especially early after they acquire infection, as I showed you in some of those modeling graphs. But there's also HIV infected people who are aware of their diagnosis, but for one reason or another are not retained in medical care, and they make up the lion's share of new transmissions. So these are people who, have a hard time getting to clinic. Maybe there is some health insurance issues, there's affordability issues, distance issues, chaos in their lives, but for one reason or another, they're not retained in care, and thus their virus is not controlled. Retained in care, but not on HIV therapy, those people also very rarely transmit, as do people who are prescribed HIV therapy but don't have a full effect from it, and certainly for the virally suppressed we see really negligible transmission, and that would be during a break in therapy. So these categories of people, including those who are not on therapy or not fully on therapy, just being in care seems to have an effect. Not being in care is a problem, and that's why a lot of our efforts now are trying to get people who are not in care back into care and understanding what are the barriers to care, and many of those are structural barriers, as I mentioned. Moving on from kind of the situation we're talking about with sex and with injection drug use, there are other exposures, and these can be healthcare, or we can see them in workplaces. This could be a needle stick in a hospital. This could be an accident that occurs in a correctional facility or on the street. But we should be really careful and talk about what an exposure really means. Percutaneous, meaning going through the skin of contaminated fluid, that counts. That's a concern. Mucous membrane exposure, so a splash with a large amount, let's say, of blood into the eyes or the mouth or the nose, can sometimes happen in emergency medical circumstances or hospitals. That's a concern. Non-intact skin, so abraded skin, an ulcer on the skin that has contaminated body fluids, that would be a concern. But the fluids we're talking about are really limited. We're talking about blood, spinal fluid, vaginal secretions, semen, fluid from a joint, fluid from around the lung, fluid from inside the belly, not in the stomach, but around the organs or around the heart, or amniotic fluid from a pregnant uterus. These are very select sorts of fluids that would have virus. You're not seeing spit, you're not seeing tears, you're not seeing sweat here. Okay. So all these other fluids are not considered potentially infectious. That would not be considered an exposure to HIV, even if there was substantial exposure to any of these fluids. Okay. So ending up, just some basic caveats and rules. Okay. Part 1. All transmissions of HIV require, just in essence, a source and a host, right? So you can't have HIV transmission if two people are HIV negative. There's no sort of spontaneous HIV generation. Someone has to be positive and someone has to be negative in order for there to be a transmission. Most sexual encounters in the world at this very moment are concordant, and most of those involve a negative person with a negative person. Okay? The efficiency of transmission is greatly affected by many of the factors that I talked about, and these can be things that are present just at that very moment and are hard to measure. And really the infectivity of the person who's the index case and the susceptibility of the negative partner at that moment in time of the exposure really are what calculates that individual risk of transmission. Most sexual transmissions do occur in newly formed relationships, especially when the HIV positive partner is newly infected and has the maximum amount of contagion risk at that point. Longer-term relationships, just looking epidemiologically, carry a lower risk, with an HIV-positive person resulting in transmission happening less, but it can occur, but is much less efficient than the other circumstances that I've talked about. And clearly we know condoms work. They work really well at reducing HIV transmission, and there's lots of data that support that. So HIV therapy, as we mentioned, reduces infectiousness greatly if taken, and the viral load is suppressed. And I mentioned before that there's also medicines that people can take to prevent themselves from acquiring the infection. So with that, I'm going to turn it over for more legalistic aspects of this to my colleague Steve. Okay,
Thank you. Also glad to be here, and I really appreciate NACDL and Center for HIV Law and Policy for putting this on. And I'm especially glad to be able to participate in a presentation of this kind that kind of weaves the medicine and the legal aspects together. The reason is that the background we confront, the sort of palette of criminal statutes involving HIV, many of them are not of recent vintage. Many of them were enacted during times when we knew much less and could do much less for persons with HIV. And they're sort of frozen in time in the sense that they criminalize acts that don't really lead to any particular danger to anyone. And again, that's because of an outdated notions about both how you can get it, how you can get HIV, how easy it is to get or how difficult, and also what the consequences of HIV infection are. So it's important for lawyers to hear what Dr. Wohl just said, because advocacy in the criminal court in one of these cases is largely going to be a matter of education. People who don't have occasion in their own lives to become familiar with HIV until a case such as this comes up are not going to naturally know these things. Dr. Wohl presented very well a lot of material about the relative difficulty of acquiring HIV and also the effectiveness of treatment that a lot of people don't know. It seems like people often have a notion that, yes, there's some sort of treatment out there, but I still hear very often in criminal proceedings that, you know, this HIV positive person is carrying a deadly weapon at all times. It's sort of exaggerated or inflammatory arguments like that. And they carry over, and they affect not only fact finders' determinations in failure to disclose type cases, but also they affect sentences in cases where HIV may not be the core of the offense or an element of the offense, but it's going to be a factor, perhaps in a sex case or another case, that affects sentencing. So knowledge and educating the prosecution and the court is going to be absolutely central. And as with most criminal defense matters, we have to look at how we're going to strategize for trial and for contesting the charge while running that parallel track in our minds about how you negotiate a favorable disposition if you're able to do that. Again, education is the key, because most of the misconceptions, virtually all of the outdated ideas about HIV tend toward the darker view than what the current reality really is. The criminal law, we know from our practices generally, is a pretty blunt instrument. And so there's a question in one sense about why criminalization, say, of non-disclosure of one's HIV status is even an appropriate thing for a legislature to do or for a community to prosecute. And it's especially clear when you kind of think back to other infectious diseases or transmissible agents and how rarely criminal proceedings are used to punish transmission or threatened transmission exposure to those other agents. We don't hear about it very often, hardly at all. It's sometimes a matter of civil liability when somebody transmits herpes or something of that nature, or HPV or another agent. But we get a sense of the exceptionalism that applies to HIV when we see that it's the one that is so often subject of a criminal prosecution. What I'd want to do is just talk about some practice tips, pointers, some practical things as much as I can. We'll touch briefly on questions you should ask a client early in the case. I'll talk a little bit about motions and strategies, and then we'll talk a little bit about ethical considerations. Now, HIV criminalization is the prosecution and imprisonment of people living with HIV for things that are perfectly legal or only minor crimes for people who've not tested positive. That's a broad and general statement, but it's generally true. Sometimes we see sex workers who have a penalty enhancement added on because they happen to be HIV positive, and a pandering or prostitution misdemeanor charge becomes something much more serious, things of that nature. And it's also noteworthy that when these cases are reported on, there's a tendency of the press and local media to blow it up, to portray people as predators or serial infectors, or people who, just by virtue of their status alone, should somehow be presumed to have intentionally harmed other people. There may be no evidence behind that, but by the time the charge is filed, and sometimes, especially in the case of an indigent defendant, by the time counsel is appointed, you may have those entrenched views propagated out there by the local news or whatever. And these continue to pop up. Just before this webinar today, as we were preparing, another case in my home state popped up, news about alleged failure to disclose involving a minor complaining witness. And I won't talk about it in any detail because I don't know much about the case, but the headline was already there that this person had intentionally tried to infect the young person. I doubt there's evidence for that, but they sure didn't mind saying so. There, as was said in the introduction, 34 states and 2 U.S. territories have HIV-specific criminal laws. Lots of times these are simply failure to disclose laws. There are also matters of sentencing enhancements that can apply in some cases. And usually what we are talking about is sexual contact without disclosure, or spitting, biting, things like throwing bodily fluids at correctional officers, etc., where these issues can come up. One point to make generally is that while things are slowly getting better and there's a very active reform movement in progress right now, a lot of states, a lot of these 34 states, still have statutory provisions, usually felony ones, almost always felony ones, that will criminalize non-disclosure if one is HIV positive, they know that they are HIV positive, and they engage in certain acts, regardless of whether that particular act in that particular circumstance has any potential whatsoever to transmit the virus. So, as I've said lightheartedly, but it's a serious matter, my entire body could be encased in a condom, and yet if I know I'm positive, I don't tell somebody else, and I engage in some erotic act with that person, I'm probably guilty of a felony in my home state of Georgia, even though there's absolutely no way that the virus could actually be transmitted. And this is 1980s stuff, but it's no longer 1980, and there's resistance to reform a lot of times because of the misconceptions that we've been talking about. I'll just go through a couple of these quickly. There in the corner there on this slide says 303 people living with HIV have been arrested or charged under these laws since 2008. That is undoubtedly a low number. As we know, it's very hard to keep records of who's been charged with what sort of charges have been bargained or reduced, and so I would imagine that it's a much higher number of cases in which the threat of an HIV-specific prosecution or an HIV distinctive prosecution has been held over the head of an accused to get them to plead guilty to some other offense or to that offense. If you tested positive, you've had any contact viewed as sex, or I should say also engaged in sharing of needles, that's a problem. Generally speaking, heaven knows if you are involved in a scuffle with law enforcement and they find out that you're HIV positive, that's generally a problem for reasons we all understand. Being a sex worker, even being a positive survivor of sexual assault. These are instances where people often find themselves charged. There are a number of difficulties with these laws, and I'm talking about a lot of policy here, but again, this is the sort of thing that you want to try to convey to prosecutors and to court. These sort of strict liability or almost strict liability kinds of statutes are lacking in several of the sort of traditional elements of a criminal offense. For example, a mens rea requirement. One might think that if you're going to impose felony punishment for transmission or exposure, that there ought to be some requirement that there was an actual intent to transmit or to cause harm, and that's generally lacking in most of the existing statutes. Also, the legal background of all these cases is, again, this notion, which can be very firmly fixed in a judge's mind, or the community's mind, and or the prosecution's mind, that this is a death sentence. This is, once you get infected with HIV, your life is over. Therefore, the person who has in any way subjected you to even a small risk of acquiring that disease or infection have done a terrible wrong to you. They've essentially ended your life. These are outdated notions that we need to combat in plea negotiations and in developing cases for trial as well. I won't go into detail about the matters that Dr. Wohl very ably went through, but I will say that there's been a sort of calculus in a lot of the case law in federal and state courts sometimes where it sort of comes out of the Americans with Disabilities Act anti-discrimination precedents, where if there's a significant risk of harm to somebody, it's an exception or a defense to a claim of wrongful discrimination based on HIV status. If somebody is a, quote, direct threat to health or safety, then you can deny them a job despite their status, let's say. Well, the calculus has been, okay, we understand, perhaps, as time goes on and science gets better, that the actual likelihood of infection may be small, but the gravity of the harm is so tremendously awful that any term you use, like substantial risk, direct threat, likelihood of harm, it's automatically considered a significant risk. And while this is started in the anti-discrimination law context, it's been something that's been carried over, unfortunately, into cases that I've handled, criminal cases and others as well, often in the context of sentencing. You can educate a judge to the fact that he or she may have accepted a much greater risk to his own health by driving to the courthouse that day than the complaining witness did in the case by having sex with the accused, with your client. But the notion is often, well, I get that the risk is small perhaps, and thank you for educating me on that, but look at the potential harm in the extremely unlikely event that it did happen. No risk is better than some risk, and so I'm still going to hammer your guy. So that's a little bit bleak, but it does happen, and it happens, I think, it's so easy for judges to do that. It's so easy for judges to fall in with and kind of endorse the community misconceptions around the effects of HIV. We've got a lot of good stuff here about per act transmission, but Dr. Wohl covered that really well. It's not highly transmissible. It's not a deadly weapon, and it's not the equivalent of a death sentence. But these are, as I've said a couple times, background assumptions that we have to fight. Also, and here's a little more policy, this is, when we talk about the criminal law being a blunt instrument, these kinds of laws do not advance the public health. If you remember Dr. Wohl's slide that I think said it's not all about HIV medication. He talked about different categories of people. The undiagnosed, for example, well, that's one cohort of people who are positive and are not getting any better because they're not aware of their status. Well, what is the fail-safe defense or the absolute defense to a charge of knowing failure to disclose? It is that I didn't know. I had no idea I was positive. So when you have these sanctions out there in the community and it's known that they're prosecuted, you have a strong disincentive to finding out your own status, which is exactly the wrong message in this area where treatment is indeed prevention. So the public health suffers because the incentives are exactly the contrary of what they ought to be. These laws also tend to promote a stigma around HIV, pardon me, that continues to be extraordinarily strong. I know a lot of people who are HIV positive and living healthy lives contend that the stigma surrounding HIV disease is their biggest problem with regard to HIV in their daily lives. It's no longer clinical symptoms or anything like that, but it's the perception of them as diseased, infectious, etc. And these can only further those. Okay, let's talk about a few practical things. Again, you want to challenge these outdated notions about infectiousness and about the false belief that there's no effective treatment these days. Let's see. We want to look also, I want to talk about obviously this is a multi-jurisdictional presentation, and so what's going to matter is the statute that you're operating with in your own state. There are a few bright examples of reforms, and there are in the materials some notes that I made. One recent notable example is a California statute that was enacted just in October of 2017, and it's really quite good in the way that it embodies a lot of common sense criminal law concepts that are salutary and make the statute a lot more fairly to be applied, I think. And it requires an intent to transmit HIV, knowledge that one has HIV, conduct that is reasonably likely or substantially likely to transmit the disease or the virus, and actual transmission of the virus. Now, this is quite different from the kinds of statutes that I talked about earlier, where if you just happen to perform certain acts regardless of what your position with regard to infectiousness is, that you can be held liable for the felony. This really requires an intent to harm, likelihood of causing harm, and then actually causing harm. And I would regard this as sort of a model for reform efforts going forward. Now, you say, I've got the statute I've got, so how do why are you telling me this stuff? So, too bad I'm not in California if you're not. Again, I just think that these are worth looking at as sort of the way reform, smart reform, is going, and might be useful in negotiations with prosecutors. Another thing, when you get away from HIV-specific statutes, is to look at general criminal laws like aggravated assault, aggravated battery, attempted murder, sometimes you'll see. And these are not HIV-specific, but they can be invoked in cases involving HIV. And that's where you really see a lot of unfortunate use, as I've seen in opening statements in criminal trials and many a transcript, is, ladies and gentlemen, John Jones, the defendant, walks around every day with a loaded weapon. You know, this is the kind of thing, trying to portray this menace and this presenting the person as inherently dangerous, and also, quite frankly, presuming that they have some sort of intent to transmit the virus or to harm others just by virtue of their own knowledge of their status. So it's important to look out for those. One problem that is patent in these cases is that there's too often not an impossibility defense to attempt charges. So, for example, the notion is, okay, thanks for the information, counsel. I now understand that there's no way that John Jones could have transmitted HIV, but he thought he could, or he took a substantial step toward doing so with the wrongful intent, so he's guilty of attempt anyway. There needs to be sort of a rule of reason that would prevent attempt liability in these cases, because very often an attempted felony has a similarly harsh sentencing scheme as the primary felony. And again, this is a matter to really talk about in plea negotiations and dealing with the court. A couple other things about the statutes, just getting very practical. A lot of these old laws are kind of woven together. Sometimes definitional portions come from public health laws of the state. There may be relevant statutes in your jurisdiction that don't appear in whatever the criminal code is in your jurisdiction. It may, in fact, be in the public health title of your state code or somewhere like there. And those really bear careful scrutiny. There was just recently in my home state of Georgia, there was a case in which there was apparently plenty of evidence that the accused had tested positive for HIV, but it turns out that under the public health code, an HIV test was defined as an HIV test of a certain kind that had been approved by a certain state agency. Who knew? As it happened, there was no evidence whatsoever that the HIV test that had been given to the defendant in the case had been approved for that purpose by the state agency, because nobody in the history of the state of Georgia, to my knowledge, was aware of this requirement. And the case was dismissed for insufficient evidence by Georgia's Intermediate Appellate Court. And to my surprise, because I thought the state would really fight this, there doesn't seem to have been any request for further review in the state Supreme Court. So I'm just saying, go down, as we do in any case, when we're defending against any charge. You want to go down to the bones, go down to the roots of the criminal statute, look at the definitional sections that are incorporated, and see what mischief you can make there. You may find something like that that completely undermines the state's case or gets you a sweet deal. And one other thing I want to mention, that the Center for HIV Law and Policy has an absolutely important compendium of federal, state, and territorial criminal laws relating to HIV. I've cited in the materials, it's called HIV Criminalization in the United States, a source book on state and federal HIV criminal law and practice. It's very useful, it's pretty comprehensive, and it's a great start for looking at any of these cases. Now, I keep talking about outmoded assumptions and science and the need for modern thinking and education in handling these cases, and that means that You have to be educator slash scientist in your case. One of the fun things about what we do is the requirement that we become many experts about subject matter when we try a case. And while being a mini expert can be a dangerous thing, we do want to at least turn to those more qualified than ourselves, look at experts in the field for any number of purposes. You're probably going to want an expert to talk about infectiousness, rates of infection per act, consequences of HIV, etc. Now you may say, wait, what does this have to do? The problem with these old statutes is it's only got 1, 2, 3 elements, and all of this policy stuff you're telling us isn't strictly relevant. And you may get that excluded at the guilt or innocence stage. But certainly for sentencing at the very least, and I think earlier very often because of the importance of getting this stuff to the other side with regard to plea negotiations, you want to really make a full presentation. Once you're perfecting pretrial motions, you want to have some kind of affidavit from somebody like Dr. Wohl talking about whatever the particular issues are in the case to kind of get the court off of its initial presuppositions. And I have had infectious disease docs testify several times at hearings. I think it's invaluable. As we know, in sentencing, when we're after conviction, we're talking about what is usually a very broad pool of discretion for judges. They don't, as long as we're not talking about a factor that would be an element of the offense, that is something that increases the statutory maximum for the crime, we've got a broad and largely, practically unreviewable pool of discretion that judges can use to do things harmful to you and to your client. And so that's why it's so very important to pull them away from that. I mentioned earlier this sort of calculus wherein every risk, no matter how small, was deemed to be significant, and how that had migrated from discrimination law under the ADA to some criminal cases. I've suffered from that myself in a federal criminal case a few years ago when these not very helpful cases were cited against me. And you know, it's one of these things where as the science continues to develop, you're in the position as a litigating matter of saying, okay, we understand the precedents from 2010, but look what science can do now. And we understand about what the court said in 2012, but look what science can do now. It's really hard to get them over that hump. Stare decisis is not our friend sometimes, but it's the kind of thing that I think zealous advocacy really compels us to keep trying on when you have a particularly reluctant court. And I don't want to suggest that everything is all bleak. There was a great case in 2015 from the Court of Appeals for the Armed Forces, the highest military appellate court, United States versus Gutierrez, which is in the notes. There was an aggravated assault conviction where the element of the offense was that an action had to be taken that was likely to cause death. And the Court of Military Appeals in this HIV positive persons case said no, the transmission, the act that supposedly threatened transmission was not efficacious enough, was not likely enough to transmit HIV, that it could be considered likely to cause death or bodily harm. And they reversed that conviction. And then in 2017, the same court characterized that earlier holding, quote, as a course correction where a minimalist approach regarding what constitutes likely had crept into our jurisprudence in HIV cases. I love that, and it's worth citing because it points out the exceptionalism that applies to HIV, and it's a court very candidly saying, hey, we got off base here. We have left logic and the real meaning of substantial or likely aside because we were so freaked out about the purported harms of HIV. I've cited some other cases, and they're not all brand new. There are some hopeful cases going back, but there's some decisions from Tennessee Appellate Court, Iowa, Illinois, and I think a few others that I've got for you. But as with any expert, you want to retain them early if you can and consult with them. And if for some whatever strategic reason it's not appropriate for the doctor to ultimately testify or the provider to testify, at least you've been able to consult with them. You've made yourself knowledgeable, and you've been able to put on a presentation that is persuasive and hopefully that would hold up on examination on appeal. Also in the materials are a set of questions for an initial interview with somebody in a failure to disclose case. They're just suggestions, of course. If you're listening to this, you know enough to know that these were going to be very fact-specific encounters. The bummer, of course, is that very often a lot will have already been done. Perhaps, statements made or admissions made or other factors happened, other evidence created prior to your entry into the case. But I do think it's important to interview fully and thoroughly. I want to point out or highlight especially the importance of preserving without delay any communications between your client and the complaining witness in a failure to disclose case. Those communications that are in your possession or lawfully accessible to you, because it's Facebook world, and social media, text messages, other social media type ways of communicating are going to be abundantly full of recriminations, threats. Why didn't you this? I did. Why? All kinds of animated communications between the so-called victim and the client, including, in fact, evidence that they did in fact know about the HIV status of your client. So important to do that. You also want to, and this touches on something that we'll talk about also in the ethics portion in just a minute. But you also want to be clear with your client on who knows about their HIV status. If the client comes to you under circumstances where you're already aware that the client is HIV positive and knows that, you want to be really clear. Don't assume that mom knows or that spouse knows or that any other particular person knows. It's for a variety of reasons, including ethical obligations, but also just planning the case and learning who your client is going to be depending on for support during the proceedings. You need to know what different friend groups or family groups know. Let's see. Legal issues, privacy of the client's health information. There tend to be public health code protections in most states about limiting the proper disclosure of HIV-related information. They usually are a little Swiss cheesy. It seems like if you're charged criminally, then all bets are off. And in too many states, I think, it makes it automatically permissible for at least some agencies to disclose health records and other material by virtue solely of the existence of the charge. I think that should be challenged. You want to come at the court with state or federal constitutional challenges, if nothing else, based on privacy rights, to any provision that says just because somebody has been accused in an HIV-related case that merely by demand or subpoena the state should be able to dredge up their medical records for their entire lives. That's quite broad, and I think there should be a showing of compelling need rather than just what seems to happen in my experience, which is that law enforcement agency A talks to jail or other agency, public health agency, and boom, they get the information just because they've asked for it. Not permissible, but nobody's going to police that if we don't. You also want to do as much as you can, I think, in chambers. I'm all for open courts, but there is great potential for prejudice in these cases, the more that is known and broadcast in the press or even in open court. And so to the extent that you can, I think you want to really argue for as much in-camera proceeding as possible, just to limit the harms from disclosure and the prejudice to your client. You want to move early to secure funding if you're representing an indigent for expert witness fees, consultation fees, etc. So that's, again, something that's fairly routine for us, but something that's indispensable here. And let's see. It does seem there's, with regard to disclosure of information, there's, again, often a subpoena is deemed enough. I think there are, it's an open question in a lot of jurisdictions whether something more substantial, such as a warrant-type procedure, should be required before information, treatment records and the like are just handed over. A lot of times, fortunately, you'll have providers who will simply refuse unless they're properly compelled to turn over client records. But this is, we can't rely on that. It's something that you have to look out for and plan about. Constitutional challenges. These are tough because there's pretty broad police power, I guess you would call it, in most jurisdictions with regard to the public health. As a general matter, I think the constitutional limits of what a government can do to safeguard the public health are not that often tested because in true emergency situations, I think that power is pretty broad. But I do think that it's possible, given what we know about HIV these days, to come up with even rational basis challenges to the statutes at issue. You can perhaps concede, I'm just thinking out loud here, but you can perhaps concede the legitimacy of an interest in protecting the public health. But the point is, do these draconian provisions, do these draconian restrictions, do they fit that purpose? And are they the least restrictive way to achieve it? So that's maybe a little way to get a little bit of juice. Even if you're not ultimately successful in your constitutional challenge, we all know that we make motions for a variety of reasons, including wanting to gain a strategic leg up or educate the court, even if we don't necessarily expect to win relief. In terms of motions in limine and evidence to be presented, you want to preclude the state from using inflammatory rhetoric, as I've mentioned a few times, slow-acting poison, death sentence, all this dramatic stuff. And I don't mean to make light of it in a frivolous way, but it's really quite ridiculous what sometimes prosecutors will get away with. Especially, for example, in closing arguments or in plea proceedings and sentencing proceedings when there's no jury there and maybe no constraint on what the prosecutor can say. You want to police that and make sure that your client doesn't suffer because of reckless and exaggerated use of language. Post-arrest silence. In a case of non-disclosure, whatever client may or may not indeed have said after his or her arrest could be important, and you want to safeguard the Doyle versus Ohio type rights that you have there. And also, since we're going to be talking usually in these cases of non-disclosure or alleged non-disclosure about who said what to whom and who told what to whom, you want to look at either defending or attacking as need be the admissibility of those social media and other messages There are a variety of techniques to do that that are a little bit beyond the scope of this particular presentation, but it's something you want to look at in terms of authenticity and the like. When you get to sentencing, you know, again, I don't think I've ever won an Eighth Amendment motion, but I sure have made a number of them. And sometimes I do so because the court needs to understand the client's plight, and you can be quite the artist in portraying for the court the circumstances that your client faces. That goes to another point that I'll kind of close on right now. Let's see. Don't want to miss. Before I go to ethics. You know, we've been talking about, and Dr. Wohl talked about, the fact that treatment is very effective, and that if your viral load is undetectable, the chance of transmission of the virus is close to zero, if not zero. People don't transmit. There's a danger here in sort of exempting from the reach of the criminal law those who are able to be on meds, able to maintain an undetectable viral load, and as compared to those who may, for any number of reasons, lack treatment. In that slide that he had, the second group, and it was the tallest one, it was the largest number of people, were those who are aware of their status and yet aren't in care. And there are a variety of reasons for that. Structural reasons, as Dr. Wohl mentioned, that include poverty, things that seem frivolous or trivial, like lack of transportation. It's not frivolous or trivial if you can't get to the clinic, can't get to the pharmacy, can't get to your meds. Racism, transphobia, fear of physical harm from a partner, etc. All kinds of reasons can limit people's adherence to or accessibility of treatment. And so we want to make sure that we're keeping that in mind, especially where indigent folks are concerned. Mental illness is another one. Such that we're not creating sort of a two-tiered system where as long as you take your meds, you're okay, because it slides so easily into this false notion that if you're not taking your meds, you're one of the bad guys and you deserve some kind of sanction. So we want to get away from that, and it's a challenging thing to do sometime, but it's really important because not everybody who's not on treatment is culpably not on treatment. When we talk about ethical considerations, we're largely, well, we're talking about a number of things, but I'm going to talk about confidentiality. Again, the stigma is important. It affects people long after their case is over. Not to mention swaying fact finders sometimes against them. So you want to limit the disclosures as much as you can. As it says at the bottom of this slide, do not assume that the client has disclosed their status to any particular person or group of persons. If mom and dad are coming to all the court proceedings and it's an HIV failure to disclose case, you might presume that mom and dad know. Don't. You don't know that until you know that. When we look at the professional rules of conduct, like Rule 1.6, that talks about the use of confidentiality of information or the protection of confidentiality, note that when you get into exceptions to the rules of confidentiality, like the permissive disclosures when you're reasonably certain death or substantially bodily harm is about to happen or to deter a future crime, just filter in what we know now about reduced potential harm due to treatment and other factors. In today's clinical world, I think it's much less a frequent occurrence that these kinds of exceptions to the confidentiality requirement would apply. It's going to be a rare instance when a permissive disclosure like that is going to be appropriate. I think I wrote it a little inelegantly here, but what I meant to say in this one is, while a single disclosure can certainly mushroom and create problems for years on end, the cat out of the bag theory does not apply. That is to say, If there's been some disclosure in some context, don't assume, oh, well, that's awful, but confidentiality is not a concern anymore. Each repeated disclosure is not only an ethical violation if you don't take reasonable efforts to preclude it or prevent it, but it's also a new occasion for potential harm to your client. So let's see. The Center for HIV Law and Policy, which, like NACDL, is a fantastic organization, suggests that if you're listening to this, you might be interested in counseling people with HIV, drafting amicus briefs, representing them in proceedings, talking to them about local practice and procedures, because every jurisdiction is different, serve as a contact point or a resource attorney, review draft legislation, or engage in any of these other activities. This is a joint effort among a lot of people who are trying to bring HIV criminal law, HIV-related criminal law, such as it is, into a more fair state and a state that's more consistent with science and reality. So I guess I'll leave it at there.
It's perfect timing. Thank you so much, Steve, and thank you so much, Dr. Wohl. Before we take questions, what I want to do is I want to take this opportunity to read NACDL's position with regard to HIV criminalization. Back in May of 2016, NACDL released a resolution, part of which said that NACDL hereby opposes all laws that base criminal liability and/or penalty enhancements on one's HIV status rather than on the intent to harm another individual. Accordingly, NACDL supports the repeal of such criminal laws as fundamentally unfair and unjust, recognizing that outright repeal can result in the abusive use of existing statutes. NACDL also supports modernization of these criminal laws to incorporate strong principles of intent and proportional punishments. And this was touched on again and again in the presentation that you just saw. I also want to provide you with the website for the Center for HIV Law and Policy. It's hivlawandpolicy.org. It was included in Steve's presentation. And I would like to remind all the viewers about the supplemental materials that you're going to receive as a result of this presentation. We included, Steve was very kind to include a client interview guide to help guide the way that you would begin initial talks with clients, a guide for representing clients who are HIV positive, as well as practice questions in an issues packet, a sample sentencing memo. Dr. Wohl created a sample medical expert affidavit on HIV transmission, as well as a sample expert opinion. These are all resources to help you navigate constructing a defense for these cases and how to begin conversations with experts, as it was emphasized time and time again that experts are very crucial to these kind of cases. Also, Steve mentioned the HIV Criminalization U.S. source book that the Center for HIV Law and Policy created, and this is a comprehensive guide that is a survey of 50 states, military, federal, prisons, as well as U.S. territories. It includes the statutes, related case laws, and analysis of some categories of statutory provisions to help aid you in understanding the laws that are being used as a weapon against your clients. So some questions we received. Steve, this question is for you. There are two that I'll ask at once. How successful have you been using the defenses outlined in your presentation, as well as do criminal HIV transmission sentences include registering as a sex offender? If so, is there a way to get that waived?
How successful have I been? Most of my successes in these cases, I think, have been what I would call soft, which is that I am pretty certain that we've achieved a more lenient sentence than would otherwise have been the case. Because of the kind of bare bones nature of my state's statute, I wish I could tell you I've brought home an acquittal or two on those, but that hasn't happened yet, because so much that is defendant favorable tends to be ruled out on relevance grounds, which is, I guess, why I talk a lot about sentencing in what I was saying earlier. That I should say, though, and I hope not defensively, is not a trivial matter, because I've had some federal sex cases where the sentences are just outrageous. And, if you can get a departure of any kind based on court's better understanding of HIV, that can be a significant thing. Oh, I should have mentioned, sorry, in the federal system, you probably want to object as early as the pre-sentence report to the inevitable line from the probation officer, which is that among the factors is that the defendant exposed the so-and-so to a dread disease, all of this. You get some real medieval stuff occasionally from certain probation officers, certainly not all, and you want to object to that and then supplement at the time of a sentencing memo. But anyway, with regard to sex offender registration, it's really a state-by-state thing. I regret that since these cases, these charges often accompany other sex-related charges, it is a frequent occurrence, I think, that people get stuck on the registry. They may not get stuck on the registry because of this particular count of conviction, but it is a problem and is unfortunate for all the reasons that sex offender registration is generally problematic.
This question is for both Steve and Dr. Wohl. Can you recommend any tips that attorneys can use to explain complex medical concepts to juries or judges? I know, Dr. Wohl, you've also done a presentation for prosecutors, and so how should one think about breaking down those concepts for people?
Yeah, so I think hopefully I was able to be somewhat understandable in my presentation. Those are the kind of terms that I think most folks can understand, and I think prosecutors and judges as well. I think the concepts that Steve, I think, has really done a great job in articulating as a non-medical professional, I think is a good example of that, and I think he reiterated some of the key points that I made too, which is really clearly that not every transmission, I think we have to just really kind of erase some of these old myths and assumptions that I think just telling someone that you can have sex with someone who's HIV positive and not get infected is already a leap. Because I think most people assume that it's a 1-to-1 ratio. So backing that out and trying to replace that with some factual information that it's on the order of 1 in dozens to 1 in thousands. And in the case of someone who's on therapy and has an undetectable viral load, pretty much impossible. So I think that's news already, and that would lead to more enlightenment on the side of the court. And then I think some of the concepts really just breaking it down. And that's where a medical expert, so in the case that we just discussed, that I think is in your source materials, I provided assistance to the defense attorney just to try to explain the medical record and kind of break it down and deconstruct it, and was able to point out some real important points that were able to be used when he went before the judge.
You know, call it cheesy, call it a little cliched, but things like, Judge, you took here are the numbers from the National Transportation Safety Board. You took an X times greater risk when you drove to work this morning than there is a risk of this. I say cheesy or cliche because maybe it feels that way sometimes, but I think these are concrete comparisons that you can make that I've actually had a little bit of success with. And the problem we have, as we discussed before the webinar, is sometimes folks just don't believe you. I mean, you can show it statistically, and we're really getting over a very entrenched, no, I've always heard that this is the worst thing in the world. So we got to just keep fighting that, and I think the more you can be creative about presenting the truth, the more chance you have of it actually getting through.
One thing I'll just add real quickly is, and I meant to mention this, is really, the science has really changed a lot just within the last 5 years. I mean, there's a lot of people who think really long and hard about this, and we didn't have as much research as we have now just recently that shows that undetectable really conclusively equals undetectable. We didn't have things like PrEP that prevented people from acquiring HIV. So there's just so much that's happened really just in a very short period of time that it's no surprise that many people don't know about them.
Dr. Wohl, keeping with that, if there were 3 takeaways, a medical takeaway that you could advise lawyers to maybe headline when they're making these kind of arguments that you think are most persuasive, what would they be?
Yeah, so I think one thing that we keep harping upon, I think HIV is no longer a death sentence in the United States and most parts of the world. So anyone who uses that terminology is really living in sort of a time warp. And I think calling that out and making it very clear that nowadays very, very few people, life expectancy for people with HIV is now really approximating that of people without HIV. So it's no longer, so it doesn't qualify anymore as a death sentence. In fact, the vast majority of people with HIV who die don't die from their HIV disease. They die from things that everyone else dies from. So really, really important that it's no longer a death sentence, number one. Number two is you can't transmit unless you have virus detectable in your blood. I'm not talking about checking virus in any genital fluid. If it's low in your blood, it's low enough in your genital fluid. We're not seeing any transmissions occur. Thousands of people studied, all sorts of relationships, no condoms used. We're not seeing transmission. I think those are 2 really major points. I think a third that I like that Steve mentioned is if someone's not on therapy, again, the risk of transmission is still pretty low, except in the most extraordinary circumstances, like the perfect storm. Most of those circumstances that you're going to encounter are not the perfect storm of high viral load, genital ulcer disease in both the person who's acquiring the virus. You can see the lineup. That's going to be very unusual. So again, you're talking about a pretty rare event, even if the person is detectable and not on therapy.
Well, at this time, I'd like to thank Dr. Wohl and Steve for taking the time to present this information. I'd like to remind everyone that our role as defense attorneys is to humanize our clients and to remind the court and the state and the public that our clients are not machines of death, but they are humans who are entitled to the protections that we can offer them. And that may require, in building this fortress of protection, that we examine our internal biases as well as the biases that the court may have, that we push and we challenge the law even when there is no space that has been recognized for such challenges to be sustained, and that we are vigilant in maintaining our education about this issue and educating others about the issue. So, thank you.
Thank you.
Thank you so much.